Only mode.
Good afternoon. My name is Cheryl O'Connor, and I am one of the managing directors and principals at 3D Asset Management. On behalf of everyone at 3D, I'd like to welcome you to today's Advisor Success Series webinar featuring Jason Roberts. 3D is dedicated to helping advisors grow their business by offering unique practice management solutions in wealth management, retirement plans, and retirement income. Before we begin our presentation today, Phil Lubinsky, our retirement income specialist, will provide a brief overview of our retirement income program, Wealth Conductor, which will be referenced in Jason's presentation today.
Thanks, Cheryl. Actually longer than 3.5 years ago now, I teamed up with 3D Asset Management to co-develop, I guess what I would call a full solution retirement income program that would really be unique in the marketplace. Having spent my entire career specializing in retirement income and co-developing 3 other segmented or bucket type programs, I just knew there was nothing available to advisors that provided them a technology that had the ability to create, implement, and manage a plan that was on a single platform that would create automated tracking reports specific to the income strategy, that provided automated analytics that dealt with the plan's progress along the way, and allowed for modifications that would reflect what the client's changing needs are, which there are many during retirement, and was product agnostic. Additionally, there was nothing for advisors that made available current, live, ongoing training and specifically on retirement income issues, that had FINRA reviewed sales and marketing materials, had case design support, and practice management support that would ultimately lead to a successful practice transition. Advisors that are currently enrolled in the Wealth Conductor program have referred to it as a business in a box that's allowing them to brand themselves as retirement income specialists. In May of this year, 3D Asset Management contracted with our guest speaker today, Jason Roberts. Jason just completed his due diligence report, which concludes that this program is in alignment with the new procedures we're all going to be subject to under the Department of Labor's fiduciary standards. At the end of Jason's presentation, you'll be given information on how to learn more about attending special webinars specific to Wealth Conductor. So with that, I'm going to turn the microphone back over to you, Cheryl, so you can introduce today's featured speaker.
Thank you, Phil. If you would like to learn more about our Wealth Conductor program, information will be provided at the conclusion of today's webinar. During the webinar, you will be in listen-only mode, but please feel free to submit questions to our presenter during the presentation through the Q&A function, and he will address as many as time permits at the end of the presentation. It is now my distinct pleasure to introduce our guest speaker, Jason Roberts. Jason is the founder and CEO of the Pension Resource Institute, PRI, a firm that delivers strategic consulting, training, and technology-based solutions to broker-dealers, RIAs, and asset managers for serving the needs of retirement investors. He is also a founder and shareholder at Retirement Law Group, RLG, a law firm specializing in ERISA and investment-related matters. Jason has been repeatedly recognized as one of the 100 most influential in defined contribution by 401k Wire, a rising star by Super Lawyers magazine, and was selected by Investment News as one of the top 40 advisors and associated professionals under 40 in the financial planning industry. Welcome, Jason.
Thank you, Cheryl.
Muted.
I'm slid in just by a nose for the under 40, would not qualify anymore, but I would appreciate the generous introduction there. And I want to get started here in making sure that we're all on the same page. There's a lot of information out there, a lot of conflicting information, and I think to really understand how to apply these concepts and to some of the solutions that we're going to address later in the deck, particularly retirement income planning, we need to all be on the same page and in agreement as to how the rules apply. and how the rules apply differently when we talk about different products or different compensation. So we're going to go through the primer, just the 101 version of the definition, the expanded definition of fiduciary, and then just pick a couple of the aspects out of the BICE, some of the real foundational aspects out of the best interest contract exemption, again, so we can then apply some of the ways that the retirement income planning experience overall will help meet those requirements under the best interest contract exemption, if that is in fact applicable. So when we I almost hesitate to ever use this slide because so many of the advisors we work with have been steeped in ERISA because of their interaction with retirement plans and employer-sponsored plans, but I do think it's helpful, particularly now that we've expanded the definition of fiduciary to include more activities. Advisors who were not previously considered fiduciaries now will be, and then obviously the biggest impact of all of this being IRAs and IRA rollovers, where ERISA fiduciaries, they're accustomed to these rules, and now we're really applying them where maybe traditionally they applied but weren't necessarily being enforced. So I think it is helpful to really understand where this all comes from. And if you think about ERISA, ERISA was signed into law in 1974, and this is right out of, as you can see here, the Section 321 of ERISA. Anytime you see a Section 3, you know that's a definition. The 21st definition is the one and only place that a fiduciary is defined. And if you are familiar with the penalties under ERISA, which we'll get into a little bit of that today, you'll know that one of the penalties is personal liability. There's certain transactions that, regardless of your intent or the outcome, are just per se prohibited. And so suffice it to say, it's a very technical law, and there's a lot of significant penalties associated with violation of that law. And so if you look at particularly with respect to fiduciaries, so these three different ways one can become a fiduciary, pretty clear cut. If you have discretion, you know it. There's no question that you're going to be a fiduciary if you have discretion. If you have discretion over the administration of a plan, like a plan sponsor would, whoever's making the final decision relative to hiring service providers or changing funds in the plan and so forth, then they're a fiduciary, they're going to know it. It was this middle one that had a lot of people concerned that, well, investment advice means a lot of different things to a lot of different people. If we're going to be subject to this new legislation in 1974, we want to know what that means. And so a year later, the Department of Labor created a regulation to define investment advice for purposes of Section 321 of ERISA. That's commonly what we're looking at over here under the current test on the left-hand side of the screen, commonly referred to as the 5-part test, although I would submit that, and one of the things that when we train advisors, we really talk in terms of a 3-part test. And as you'll see here, the coverage starts with the proposition is, am I providing advice concerning securities or property? If the answer is no, you're not a fiduciary. Am I doing that? If the answer is yes, am I doing that on a regular basis? Well, common sense, we know what that means. More than once. Doesn't necessarily have to be quarterly or annually, but it's something periodic, certainly more than once. The third and fourth ones here, I really feel like these are sort of throwaways, at least in the world that we live in working with financial professionals. Is that advice delivered pursuant to an understanding, and that can be written or otherwise, that it's the primary basis for investment decisions of that client. Well, if you're sitting across the table from a client and you're the only person in that room that has financial advisor on their business card, that's, we kind of feel like those are throwaways. The last one is critical. Is that advice individualized based upon the particular needs of that client? And so if it's securities property on a regular basis and individualized, we're going to default to you're probably a fiduciary under the current test. Now compare that to what is essentially a two-part test under the final rule. This will become law of the land April 10th of next year. Now, as opposed to securities or property, the most significant expansion in my mind here is that we have now included third-party advisors or managers, this concept of recommendations concerning the management of securities, which we'll look at in a minute, and recommendations to take distributions from a plan or IRA. So that's sweeping compared to securities or property. And it can be one or the other of the next of 2 and 3 here. It can be pursuant to an understanding that it's based upon the particular needs, which is sort of like what we meant over here by individualized, or it could be specifically directed to a recipient or recipients. So we talk to retirement plan advisors a lot about, historically, if you were giving investment recommendations in a group setting, then it would be very difficult to claim that that was individualized based upon the needs of any particular participant. Under this new standard, we have to be careful even in a group setting if you're specifically directing to various recipients this advice. So more expansive net in terms of the type of advice, and certainly a lower threshold in terms of the test or the function that how that advice is being directed. So this management of securities, I don't want to get too deep into the academic weeds here, but I do find it curious that when we got the proposed rule to expand the definition, I saw management of securities along with those other activities, and I thought, okay, well that, just like investment advice, means a lot of different things to a lot of different people. Wonder what it meant to the DOL. Well, where do we find that? We go to the preamble. So the preamble of the proposal said, had 2 paragraphs regarding the management of securities, both of which had to do solely related to proxy voting. So one could reasonably conclude that the department really meant the literal management of a security by its shareholders. Well, come to find out in the final, in the preamble to the final, we get more clarification. Well, here's what the department really meant by management of securities. Recommendations concerning investment policies or strategies, portfolio composition, investment account type, which is going to become very relevant here as we progress through the presentation today, and then obviously distributions. We knew that was part of the deal. But I would submit these first 3 were news to a lot of people, and we know where the language comes from. It comes from the 75 regulation, but just think about how difficult it would be to provide any degree of value to, let's say, an IRA client in particular, where you, as a non-fiduciary, it's almost going to be impossible to meet with a client, at least in that individual context, and not give advice concerning one or more of these enumerated factors. So what does that mean? What is that standard of care now? Now that I'm a fiduciary, what does that require of me? Well, it requires first that I be objective and that I give appropriate consideration to facts and circumstances that I know or I should know to be relevant. And so that's one where we find ourselves talking to retirement plan sponsors about historically, because a lot of times they may not, the only plan they manage is the plan is their company's plan. So we're talking to them about the value of hiring an experienced advisor just to know what should be relevant, things they should consider that they may not otherwise know. And you're going to be held, an advisor is going to be held to a standard of care where you're going to be expected to know that before making a recommendation as a fiduciary to an IRA client, or in the context of an IRA rollover, for example, that there are a multitude of factors that are relevant to somebody's retirement saving strategy, retirement income planning, etc. So I think that's the biggest surprise to a lot of advisors who maybe have historically focused on serving individuals and working in more what we would call, the retail side of the business, as opposed to serving institutions and being familiar with this. You can't turn a blind eye, in other words, to things that you should know to be relevant according to the Department of Labor. So, and again, this is just the sort of level setting here, but okay, now we know what that fiduciary standard of care is. What are those things that I mentioned earlier that I said no matter how well intended you are, or no matter how great the outcome might have been for that client, if you do X, then you are held liable, or you are engaged in a prohibited transaction. And these are, we paraphrased here a little bit to make it more approachable, but essentially the first one is self-dealing. And a lot of times this is where you will hear the term thrown around, level compensation. Fiduciaries have to have level compensation. Well, what does that mean? Well, that really means they can't self-deal. We've sort of paraphrased the requirements, the prohibition of self-dealing to say that you cannot increase your compensation based upon the investment you recommend. So if I'm going to charge you a level 1% in an IRA, and I recommend ABC fund, and it's a load waived A share, and there's a 12B1, and that's going to come to me or my financial institution, now I have engaged in self-dealing. I've also triggered this prohibition that's the third bullet point. I've now received a third-party payment. That 12B1 is paid by the mutual fund and not the client. So that's where, you know, in ERISA, it's well established that that additional compensation needs to be offset against the advisory fee to avoid the prohibited transaction. In IRAs, that has not been traditionally enforced by the regulatory agency that has sole enforcement jurisdiction over these Section 4975 prohibited transactions in the Internal Revenue Code that apply to IRAs. So the dual representation, I feel that we need to at least mention that. It doesn't come up as frequently as commissions and 12B1 and trails and so forth, being in the third-party payment, or an ability to affect my compensation or that of an affiliate through giving advice that would be considered self-dealing. But this notion of dual representation, if you think about those of you that are dually registered or work for a dually registered broker-dealer RIA, you may have circumstances where one client, you know, you represent a client as a fiduciary who wants to buy a security, and another client of the firm is holding the same security that they want to sell that. And now technically the firm would be in an agency cross-trade. In other words, the firm would be representing both parties, one of whose interests are adverse to your fiduciary plan or IRA client. So these are things that your home office, compliance, supervisory, legal personnel should be dealing with. But I just wanted to set the stage so that we can talk more concretely about some of the ways to ensure that you're complying and that you're not subject to or finding yourself in a position where you're defending a prohibited transaction. So now let's focus just a bit on rollovers. Rollovers, it seems like all of our clients ask, you know, for good reason. I mean, that's a lot of employees and a lot of individual savings are sitting in employer-sponsored plans, particularly 401k plans, and there may be limitations on whether the degree to which that individual can achieve their objectives by staying in the plan. And so I thought it's important here to compare the current rule versus the new rule, and then we'll get into some of the BICE considerations and then some of the retirement income planning solutions. If those of you that work with retirement plans, you may recognize this slide, or certainly the rule, the advisory opinion from the Department of Labor issued in 2005, where the department said is very specifically, if you do not provide any fiduciary services to that plan or its participants, then making a recommendation concerning an IRA rollover or the distribution is not going to make you a fiduciary. That's what we call the green zone. A lot of our clients that are plan specialists, they would fall in this yellow zone where they're providing advice, they are a fiduciary, but they're doing that in the boardroom, and at the individual participant level, they may be providing education, or there may be a third party like a education team from the provider, the platform provider providing that education. In any event, they're still a fiduciary, so they had to proceed with caution because the rule, the opinion says you cannot use the authority that makes you a fiduciary to cause a participant to take a distribution and then recommend they invest the proceeds in a way that pays you more compensation. Well, given that most plan advisors may be charging, somewhere, let's say 25 basis points, maybe smaller plans 50 or something, we don't see that in IRAs. You have an individualized service, the economies of scale are not there, and I would say 9 times out of 10 and maybe 99 times out of 100, the advisor is going to earn more compensation than the IRA. And so then the last one here is the reason we flagged this as being in the red zone. We feel like that this is really what the DOL meant. If you're sitting down one-on-one, potentially behind closed doors with that individual, and you don't have to be a plan advisor here. This could be a individual wealth management client that you are advising for compensation on their retirement plan, even though it may be held away in an employer plan that you don't have any relationship with. You're nevertheless getting paid for advice, and that's ERISA-covered assets. So now you are in where we think the DOL is most concerned, and that is that the maybe unsophisticated participant would rubber stamp every recommendation the advisor makes, including one to take assets out of the lower cost employer plan and invest in some high commission product. So that's sort of the law of the land until April. And as you will see here, the landscape will change dramatically come April, and you will see there is no more yellow or green zone. Everybody will be in the red zone in the sense that recommending a distribution will now be a fiduciary act. And if we have the same result, which is the one I described, just that your advisor gets more compensation for advising an individual for, presumably in a more holistic context than they could in a plan, then there's an increase in compensation. And so if you go back to that self-dealing, if I'm going to give you fiduciary advice that can increase my compensation, well, now a recommendation to take a distribution is the fiduciary advice. The jump from 0 basis points if I had no relationship with that participant relative to those assets to, let's say, 1% in my hypothetical, that would be the delta that would trigger the prohibited transaction. Now that plan advisor that's at 25, if those assets stay in the plan, or 50, may have a lower delta to defend, but they still have a prohibited transaction. So the long and short of it is here, we need an exemption. And you have 2 different types of exemptions that could, 2 different types of the best interest contract exemption, which is the only exemption that would cover this activity where a recommendation is made and the advisor or financial institution's compensation increases as a result. So just briefly, I mentioned there's 2 versions of the best interest contract exemption. There is the level fee fiduciary, which says that if the only compensation you will receive is in connection with the reinvestment of the proceeds of that distribution, of the rollover, in other words, in the IRA is a level asset-based fee that doesn't vary based upon the investments you recommend. Then it doesn't have to be asset-based fee. It could be a level hard dollar fee, but it cannot vary based upon investments you recommend. You can dispense with one of the first requirements here, which is the written agreement. And there's a lot of nuances there. We're not going to try to make everybody a best interest contract exemption specialist today. We wanted to set the foundation, as I mentioned earlier, to get into the details about retirement income planning, and so you can have an appreciation of how that will help. So we won't get into all of the nuances of a written agreement. Suffice it to say, though, that does open up another remedy for a client, or as some are starting to think of these individuals as would-be plaintiffs, that they can now sue for breach of contract under that written agreement, particularly the warranties that are being made under that written agreement, whereas under the level fee fiduciary version of the best interest contract, there is no written agreement, and so the remedies would be limited to those that are either under ERISA that the DOL can enforce what the money leaves an employer plan, or if it's regarding the reinvestment of the proceeds, then technically, sure, the 4975 prohibited transactions are still in play. But if you're level fee fiduciary, you're really talking about SEC rules at that point. So, in any event, that it is a more streamlined path. But there's going to be examples where your client's needs may, if you are dually registered, you may find that a mix of fee-based and commission-based solutions is optimal, depending upon their particular needs. And so we need to figure out how do we deal with that, and that's what we're going to get to here in a minute. But in any event, even if I'm a level fee fiduciary, I have to adhere to these impartial conduct standards. I have to disclose my compensation and material conflicts, and I have to retain certain records in the event that those were ever requested, either by the Department of Labor or by a plaintiff. I need to have those records on file to demonstrate I complied with the conditions of the exemption, even if I am a level fee fiduciary. Just briefly here, the impartial conduct standards, this is going to be relevant in a couple of slides when we start talking about reasonable compensation. But initially, we recognize that if there was no conflict, then the standard of care is that I act solely in my client's best interest. And this is very different. I know a lot of firms, particularly some of our fee-only RIA clients, will say, hey, Jason, I've been a fiduciary to my clients for years. Nothing's going to change in my world, right? And I'll say, no, unfortunately, your standard of care under the Advisors Act is to disclose material conflicts, and your client can elect whether or not to do business with you as a result of the disclosure. Under ERISA, those same material conflicts are considered prohibited transactions. And if we don't operate under an exemption, then you're responsible for not only losses, but excise taxes, disgorgement, etc. So it is something that even fee-only RIAs need to pay very careful attention to, because in the context of an IRA rollover, for example, I do have a conflict. If your money stays in the plan, I don't earn anything in a lot of cases, and if it comes over to my RIA, I'm going to earn something. And so this is why now I need to show that it's in your best interest. I can't receive fees in excess of what would be reasonable, and that goes to me as an advisor, my firm, any affiliates, or even related entities with which me or my affiliates or my firm has an interest that may affect my best judgment. And then I have to not make any misleading statements regarding my fees or conflicts and so forth. So there's a lot there to unpack. We're just not going to do it all today. The last thing I want to talk to you about here in the primer is that best interest standard. And this is very imperative. That the standard recognizes, again, that there is a conflict, or else you wouldn't need an exemption, because there wouldn't be a prohibited transaction in the first place. And so to mitigate that conflict, this best interest standard requires that it be based upon the investment objectives. Your recommendations be based on investment objectives, risk tolerance, financial circumstances, and needs of the retirement investor, without regard to your financial interests or that of your financial institution, affiliate, related entity, or any other party for that matter. So this is very similar to the sole interest standard that we have seen applied under ERISA, but we haven't seen this applied and enforced on IRAs because, again, Treasury has sole enforcement jurisdiction, and they have traditionally not enforced those prohibited transaction rules against service providers. So how do we, in light of having a conflict at a minimum in connection with rollover advice, and potentially even downstream conflicts in the form of third-party payments, commissions, trails, 12B, etc., how do we navigate this exemption so that we can rest comfortably, not look over our shoulder, and know that advice we are giving is demonstrably in the client's best interest? So now is where we're going to shift gears a little bit. This is a chart that was part of the income conductor literature, and we found it very instructive, because one way to meet that standard of care of best interest. If I have to now demonstrate I've acted my client's best interest, I better know what those interests are in great detail. I need more information up front than a risk tolerance questionnaire, particularly if we're planning somebody's savings that they're supposed to live off through retirement. And so, as we'll talk about in a minute, that front-end information gathering that you're doing in the context of financial planning or retirement income planning, you're going well beyond what you would typically capture in a new account form and getting closer to that, being comfortable to say we've met this standard of best interest and gathering relevant information, or that which we should know to be relevant, as we talked about being one of the requirements of a fiduciary process. The other thing we're able to do here is start narrowing the universe of every conceivable investment or investment strategy. If you think back to that slide about the management of securities, we're talking about investment policies, strategies, portfolio composition, investment account type, for example, brokerage versus advisory. Well, if I have a substantial IRA savings or rollover balance, I may not be a one-size-fits-all. And the more we can segment or compartmentalize these goals, the more I can tailor my recommendation within each of those goals. And so I felt like this graphic, which was pre-DOL rule, does a really good job of showing that if we're going to plan your retirement, if I'm evaluating whether a rollover is in your best interest or what we're going to do with the proceeds, or even if you come over with a transfer of significant assets in an IRA, and we sit down to talk about a strategy, if I know that you can't and you cannot withstand volatility in segment 1 or 2, because that's when you're going to start drawing income from your investments, and you don't want to have any surprises there, then I can rein in the universe of what I'm considering. I can look across my options based upon my license registration, what I'm approved to recommend. And what we're telling clients is, and this is both at the supervisor level and as well as at the advisor level, we're saying, if you're going to take this segmented approach, show them show them an example of each option. If you have, in some cases maybe they want a fixed return and there's a fixed annuity may be appropriate. If they want to, in some cases in short term, something that's going to generate less volatility, maybe you have, let's say, laddered bonds or something. Maybe you have a strategy in an advisory account that would accomplish the same thing. And so by showing them what what the best option is within each of what it is you're approved to deliver, and then out of those options, recommending one as being in their best interest, and here's why, now you've really isolated that analysis and the potential defense you may have to play down the road. And that's really what we're talking about here, right, is from my experience, most all advisors act in their client's best interest. At a minimum, they want to retain that client, and acting contrary to their best interest would not help that process. But do they really think methodically about playing defense? And part of this is probably has a lot to do with my early part of my legal career. I spent about 5 years doing nothing but in litigation, arbitration, regulatory proceedings, advisors and their financial institutions. So I tend to think in a worst case scenario and say, okay, I know that in down markets, even good advisors get sued. So people, a lot of cases just don't want to lose the money. And so how do we proactively reverse engineer that worst case scenario and proactively implement some solutions to be able to play defense in advance? And at the point of recommendation, this segmented strategy where I can really narrow what your investment policies are vis-a-vis a particular time segment, introduce the available options that really come to the top within that objective, and then put forth one as being in your best interest, that will go a long way to showing the objectivity and to showing the prudence of that process that you're considering relevant information. And as you get out, obviously, into the the more lengthy time segments here, then that's where we're probably targeting higher returns, right? We still need some growth component. If this person is, just retiring and they're expected to, whatever their longevity anticipated longevity may be, well, then we're going to look for something obviously with a higher return out there, and this is where you might find that you end up recommending a combination of different products and strategies that is ultimately defensible as being in the client's best interest. Looking at this a different way, and this is kind of how I was just explaining it, is segment by segment. And I know there's a lot of people, I can actually recognize some of the attendees on the webinar today that are fee-only advisors, and they may not present brokerage solutions or insurance solutions, which is fine. But my guess is have different strategies that you're going to recommend if you segment out the individual's time horizon. And you may have a particular short-term strategy that looks very different from something longer term. There may be a tactical strategy that comes into play at some point, and how do you introduce those options even if your fee remains the same, which in a lot of cases it won't. In some cases you may be recommending a discretionary account here, a non-discretionary account here, a UMA here, or what have you, and you may have variability in terms of your investment account types, even wholly within investment advisory. So again, if you just think about it segment by segment and look and say, what are we targeting here? Are we targeting something short-term, lower volatility, and in this case, with somebody who has all three products and solutions available, they're going to ask, is this something that we can we meet this objective with a one-time transaction or buy and hold strategy? And maybe in the case of that laddered bonds example earlier, maybe that is actually cheaper for the client and achieves the same goal as what they would have been able to access through the advisory solution. Maybe not, but at least we're being objective here and we're presenting these various solutions. Obviously, advisory is going to meet the needs of more complex strategies, ongoing monitoring, more holistic sort of wealth management relationship, and insurance. Obviously, when the insurance products are going to be appropriate and would be appropriately introduced there as well. So just another way of thinking about it, but you really need a systematic way to implement something like this, and that's where we turn to retirement income planning and some of the tools that are available to you to then systematically gather the information, systematically capture your recommendations and evaluations, particularly if you're getting an acknowledgement once you prepare the plan that shows the various options. If you're giving that to the client and they're acknowledging, yes, this is in line with my goals, and then you're now implementing a plan that everybody's agreed to. Again, as a former defense lawyer, this would be my ideal file to run across, as opposed to, well, we have this risk tolerance questionnaire, we've got some notes, sporadic notes here and there, but we didn't have anything that really lays out all the options and what was recommended at what point and why. And so if we now start looking at those requirements that we talked about earlier, just looking at the standard of care, if we're gathering more information, we're going to know more about that client's interest. We're going to be better able to support that we considered relevant information and aligned our recommendations with their best interests. The narrowing of options, I can't say that enough, being able to sort of rein in the universe so you're not having to say, okay, out of every single investment I could recommend to you, here's the best one, by really narrowing that down based upon targeted return or time horizons, these various segments allows it to be a much more manageable exercise to then put something forward as a best interest recommendation. By linking the needs to current anticipated savings, that's even further digging into what are the client's interests and how has this been a prudent recommendation. Am I accounting for healthcare? Am I accounting for inflation, et cetera? These are the more macro concepts that are going to need to be part of the support for the recommendation now that we have this much more scrutinized standard of care and just a much more highly regulated world where we're going to live in now on IRAs and rollovers in particular. And again, if you present the recommendations, per segment, then you can show that vis-a-vis that overall retirement portfolio, something that may not have been appropriate as a standalone solution for a client could become very appropriate as a component of their entire retirement savings portfolio. Reasonable compensation, this is one we get asked about a lot, and again, and those retirement plan advisors and specialists certainly have a leg up here because this is something we've been thinking about, if not always, certainly since 2012 when the Department of Labor came out and issued its 408B2 regulation. And as you can see what's happened in the market since then, those who have been providing, let's say, 2 services for 25 basis points are being replaced by the specialists who can go show the client, here's my 25 services, and I'm going to charge the same 25 basis points. Now, at some point, we want to make sure you're not overcommitting there, but it really is. It's essentially getting credit for all of the things that you're doing and not being shy to articulate that to your client, and this is something you will need to work with your supervising firm to make sure that the value is conveyed in your service agreements or your required disclosures, that you're showing the full value of what you're providing, because now think about the scenario we described earlier, whether it's a rollover, whether it's various third-party compensation or an ability to increase your compensation as a result of a recommendation, you're essentially playing defense. And part of the defense is demonstrating you have developed policies and procedures and in fact that are designed to and that you're in fact complying with the impartial conduct standards. That's across the board. All of the best interest contract, the different flavors, impartial conduct standards is a common theme. One of the components of impartial conduct standards is that the compensation must be reasonable. And so what is reasonable? Well, reasonable is based on the value of services you're providing that align with the needs of that client. And what that means is you can't provide Ferrari level service to a client who's stated in no uncertain terms that they only need the Chevrolet, let's say. So if they need the Ferrari, then you better be able to describe in your agreements and your disclosures that that's the level of service you're providing. Then within those needs, okay, now what is the nature of my service? What is the frequency? What is the scope of the service? And again, if you look at something comprehensive like a retirement income plan or financial plan, you've certainly bumped up the value proposition there, because the nature of your service, well, it's I'm a fiduciary. I'm providing you holistic, ongoing advice concerning your retirement income plan. What's the scope? Well, the scope is all of the assets you're going to live on are included. So that's very different than a one-time transaction. And so the value and the reasonableness of your compensation should reflect that. Right? You should be compensated more. It's logical to pay more compensation to somebody who's doing something that is so much more holistic, particularly if it's ongoing. And that's where the frequency comes in. Right? Am I going to meet with you once a year? Are we going to adjust this plan as your needs change? Are we going to adjust this plan as market conditions change? And again, so now you can really show that you've hit all 3 of those points to the nth degree, which should allow you to support reasonableness of your compensation. There's another factor here that not a lot of people talk about, and that's the background, experience, credentials of the advisor. Even to a degree, the firm. There's value in the firm narrowing the products, products and services, and conducting due diligence on asset managers and so forth that allow the advisor to deliver more value And then the advisor, kind of just like attorneys or other professionals, you get what you pay for, and you pay for experience, and you probably pay somebody a higher fee, but you may not spend as much time with them because they can get right to the meat of the issue. So that one's really hard to quantify. Again, I'll refer you to your supervising firms there for the answers, but that's something you definitely want to be thinking about, is how do we articulate our value so we're getting credit for all of the things we're doing, and we don't just have to respond to a claim that our compensation is unreasonable in a vacuum. And then lastly here, in terms of just the obvious benefits of this deeper relationship that you would have with a client who is receiving ongoing continuous retirement income planning, you have a much more robust documentation. You can talk about these multiple strategies. You can talk about what of this, if any, could have been implemented through an employer plan, which could be waiver of rolling money over into an IRA where you have more flexibility to implement various strategies. You have a broader array of products. Sure, it may be more expensive because you're not part of a multi-million-dollar plan and having that bargaining power, but if your needs are better met outside of the plan, well, then this is a factor that would weigh in favor of an IRA rollover. If you are an advisor who may recommend commission-based products, or you may receive third-party compensation in the form of trails or 12B1, then the documentation goes a long way. And really just how I would explain that is, it's much better to defend the receipt of a commission based upon the segment triggering the buy or sell of a commission product, that time horizon in other words, than trying to defend just a cold call to an IRA client that results in a commission. In other words, the third-party compensation is received as a result of simply implementing the plan that the client and the advisor agreed to. It's not just a willy-nilly an event that would trigger a commission. If to the extent you can configure your business in a box, I think as Phil called it, or process in a box here in terms of the retirement income planning, configure that with appropriate disclosures and documentation, even better. Now you've eliminated some of the operational risks of a client not getting the right disclosure in connection with the right recommendation, et cetera, so you can streamline a lot of the reporting as well. And then just the overall plan itself. This is the one I think is, to us, was a no-brainer, but we found ourselves explaining this, and so I concluded as a bullet point. The plan itself is the process. It's that objective process considering relevant information and capturing that which you should know to be relevant and leading to a well-informed recommendation, or in this case, multiple recommendations. One that we didn't include here, but I feel like it is worth mentioning. If you, particularly a supervising firm who's going to be very concerned about class action exposure under the full best interest contract exemption, part of class action, one of the foundations of a class action claim is that it be a typical claim of the class and that there be a degree of commonality, typicality, and so forth. If every plan is unique based upon the needs of that individual, it would be very difficult to imagine a scenario where there is a class certified. There'd have to be some due diligence failure or some systemic sales practice or misrepresentation or something, and those things are much more easily avoided, I feel like, than some of the other ways you could find yourself in a class action. So just the experience of tailoring recommendations to these comprehensive information you've gathered and the needs of the client in great detail will further separate you from that potential class action ability. So I know I can see a number of questions. I want to make sure we have time to get to those, and I will turn it back over to our host to queue up the questions.
Thanks, Jason. Well, as you can imagine, we have many, many questions here, and many of them deal with compensation. So I'll try to hit a few areas. One question is, will accountants or other tax professionals engaged in a revenue share with a third-party advisory firm be held to a fiduciary standard and subject to risk for recommending clients to that advisory firm?
The short answer is yes. So it would be typically a solicitor arrangement, and those rules vary from state to state, but the Department of Labor fiduciary rule and the prohibited transactions under the tax code are federal, and they would supersede, and it is based upon the activity. So if I recommend a third-party advisor or a third-party manager, and I receive compensation from that retirement investor in connection with that recommendation, or if I receive compensation period, like in the form of a solicitor fee, let's say, from the firm that I'm referring. Now, a fiduciary, when I make the recommendation, the receipt of that compensation would be the prohibited transaction. To the degree it's not coming directly from that client, that it's not part of the services you're providing, then you would have to comply with an exemption. Doesn't mean you can't do it. Doesn't mean those relationships will all go away, but it means you need to be carefully think through the application. There are still a couple of questions we have there. On the one hand, the rule, it makes very clear a recommendation for compensation of a third-party advisor or manager. Doesn't matter if you're an accountant, doesn't matter if you're just an individual with no professional certification. It's anybody who's going to get compensated for making a recommendation to a third-party manager or advisor will be considered a fiduciary. The question becomes, though, when they wrote the level fee fiduciary exemption, if you'll recall, I'm very careful how I said it earlier, your fee can only be a level asset-based fee that doesn't vary based upon the investment you recommend. That's what qualifies you for a level fee fiduciary. Well, I'm not recommending an investment here. So does it apply? Can I qualify for level fee fiduciary if I'm receiving a third-party payment that is level and asset-based, but it's a solicitor fee? Stay tuned. Right now, what we're telling our clients, both at the law firm and at PRI, is where in doubt, we have to take the most conservative interpretation possible. And in this context, that's a third-party payment. They called out commissions in 12b1 as an example of a third-party payment that would disqualify you for level fee fiduciary. They didn't specifically call out solicitor fees. Was that an oversight? We don't know. So the notion there is you could recommend another third-party advisor manager and you wouldn't get paid anything. Or you could recommend one that pays you a higher solicitor fee. So based upon that and the nature of it being a third-party payment, we feel like there's a conflict there clearly. And we're anticipating the DOL will come out and say, not eligible, which means full best interest contract exemption. Again, doesn't mean you can't do it, but it means you would operate under the full best interest contract written agreement.
And just as a follow-up from a different perspective, another question, can the firm collect the 12b1 payment if it does not pay it to the reps?
That sounds like a home office question. So the short answer is yes. Historically, no. There was no exemption to capture additional third-party compensation, at least not in the IRA, which is I anticipate this is occurring, other than the fee offset. And you would take the advisory fee, you would apply whatever 12b1 was received, you would offset that, and now you've eliminated the conflict. And so you don't even have a prohibited transaction in the first place. But now, the best interest contract exemption, sure, you can receive that additional compensation at the firm level so long as it's reasonable. So long as the total compensation that received by the financial institution and the advisor doesn't exceed that which is reasonable given the value of services provided by the financial institution and the advisor. So, in any event, if we're talking about an IRA or a non-ERISA plan, that receipt would require you now to operate under the full best interest contract exemption with a written agreement, reps and warranties, etc., one of those reps and warranties, one of the warranties is going to say that you have mitigated that differential compensation at the advisor level. So passing it through to the advisor, not going to work. Retaining it at the home office, sure. We want to make sure that you're justifying the retention of that in light of the value and so forth. So a lot to unpack there, but the short answer is yes, you can receive it under the full best interest contract exemption.
Okay, I'm sure they're happy with that answer. Here's a situation where, you know, it's the source of the payment, I guess. A plan advisor is being paid by the plan sponsor and not by the participant at a level of 25 basis points advisory fee. If the advisor recommends that the participant roll out of the plan and the advisor now charges this individual the 25 basis points directly, is there a problem with this?
Sure. I guess one of my problems would be, what are you getting for 25 basis points in an individual advisory relationship? But that's just my opinion. I guess what I mean there is I don't want to see advisors race to the bottom with their fees to then deliver bargain basement services just to try to comply with the rule or try to avoid the rule. I would rather see you charge what your value is worth, what the services are worth, and we can navigate the rule. That's why the rule is set up the way it is. If you're doing what's right by the client, you're documenting everything, and you're providing, 1% value, 1.25%, no reason to rush down to 25. But the answer to the actual question is, and I think that's a really good question, because the prohibited transaction, we're going to assume a recommendation is made. I'm going to recommend to you to roll over, Cheryl, your plan account to my RIA. And if I receive any additional compensation in connection with that recommendation, in this case, it may be 25, I may receive 75 basis points additional comp if I recommend 1%. But under this hypothetical, the interesting thing is the employer's paying that. So I'm earning 100 basis points additional compensation. And that is, in fact, one of the very specific areas that DOL says to operate under this level fee fiduciary exemption, which presumably this is the best practice. Presumably you should be doing that under the full BICE. I can't see why you wouldn't follow the regulatory roadmap that they've given us here. But in any event, they want to know if you consider whether or not the employer is paying any or all of the administrative expenses. Your advisory fee at the plan level would be considered one of those expenses. If the participant's paying it, you essentially have, in my hypothetical, a 75 basis point delta to defend. If the plan sponsor is paying it, you have a 100 basis point delta to defend. And what I mean by defend is that's your financial interest, that we need to show that all of these factors of what the client needs, that notwithstanding that 100 basis point or 75 basis point jump in comp that you're going to have if they follow your recommendation, that it's nevertheless in the best interest of that individual.
Okay, thank you. And just one quick one, because we are running out of time and bumping up against the end of the hour. Will this new standard of care apply to existing IRAs or only money coming out of group retirement plans after April?
It will apply to, again, it's a functional test, so it will apply to any advice provided to an IRA client, whether rollover, transfer, startup. All IRAs, non-ERISA plans will be subject to the rule. And rollover has its own unique conditions, but any new advice, there is a grandfather provision. That's probably a 60-minute webinar in and of itself, but new advice will be subject to the fiduciary standard of care.
Okay, wonderful, and thank you for this very informative presentation. I'm sure we could go on with Q&A for another hour at least. But I'd like to thank you, Jason, and also for all of you attending today's presentation. If you would like more information about 3D's Wealth Conductor program, please go to masteringretirementIncome.com to register for an overview webinar. This 40-minute presentation will include information on how advisors can redefine their value proposition as retirement income specialists. Also, please visit our website, 3dadvisor.com, to register for our upcoming market commentary webinar presented by our CIO, Ben Levine. And for any additional questions, please call 3D at the number on your screen. Thanks so much again for joining us. Have a wonderful day, and we look forward to hearing from you.